Dr. Bechtel, if you're ready to start, I can ask Julie to start the live stream, and once we do, I'll if we can do that motion we had spoken about with Dr. Yang.
Yeah.
Okay. Just one moment. Thank you. Just one moment.
Angie, congratulations on your murder conviction.
This conference will now be recorded.
And we are now live. Thank you.
Okay, session's back in order. Ben, I thought I might have you as a parliamentarian kind of clarify the matter with Dr. Paul Yang.
Certainly. I brought to Dr. Bechtel's attention during the break. I listened I watched the recording of the first half of the meeting regarding Dr. Yang. As you recall, that original proposed order was a non-permanent revocation. The board amended that to a permanent revocation and approved that amendment. The order was properly amended. However, when it came time to approve as amended, there was not a motion on the floor. There was simply a roll call vote. So at this time, I asked Dr. Bechtel to call for a motion to approve the report and recommendation in the matter of Dr. Yang as amended. And if someone could make that motion and second it and have a roll call vote, we will be tip-top shape for the matter of Dr. Yang.
Do I hear a motion to approve and confirm proposed findings of fact, conclusions, and order as amended in the matter of Dr. Yang? Do I have a motion?
So moved, Dr. Cockrell.
Second?
Dr. Johnson.
Dr. Johnson? We'll go ahead and do a roll call vote. Dr. Rothermill?
Abstain.
Okay. Dr. Safran?
Abstain.
Okay. Mr. Gaccalone?
Yes.
Dr. Soin?
Yes.
Yes. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Myself, Dr. Bechtel, I have to abstain in this case, but thank you very much, Benton, for clarifying that. That was very, very important. Thank you.
Thank you all. Thanks.
Now we'll move forward with the settlement agreements. We'll start with SSAPA. Do I hear a motion to ratify the proposed permanent surrender with SSAPA? Do I have a motion?
So moved, Dr. Cockrell.
Dr. Cockrell, second?
Second, Dr. Johnson.
Thank you, Dr. Johnson. Roll call, Dr. Rothermill?
I'm sorry, I'm on the interview. So just do what I have. Thank you.
Dr. Rothermill?
Abstain.
Abstain. Dr. Safran?
Abstain.
Okay. Mr. Gaccalone?
Yes.
Dr. Stein?
Yes.
Okay. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Yes, thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Yes. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Yes. And myself, Dr. Bechtel, yes. We'll now turn to the matter of GCRCP. Do I have a motion to ratify the proposed consent one or step one consent agreement with GCRCP? I do have a motion.
So moved, Dr. Johnson.
Dr. Johnson?
Second, Dr. Cockrell.
Dr. Coccarella? Dr. Rothermill?
Abstain.
Okay. Dr. Safran?
Abstain.
Okay. Mr. Gaccalone?
Yes.
Thank you. Dr. Soin?
Yes.
Yes, thank you. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Okay, thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Thank you. And myself, Dr. Bechtel, yes. We'll now turn to APFMD. Do I hear a motion to ratify the proposed consent agreement with APFMD? Do I have a motion?
So moved, Dr. Caparella.
Dr. Carroll, thank you. Second?
Second, Dr. Johnson.
Dr. Johnson, thank you. Roll call vote, Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
and Mr. Coccoloni.
Yes.
Thank you. Dr. Soin,
Yes.
Dr. Schonstein,
Yes.
Dr. Reddy,
Yes.
thank you. Dr. Johnson,
Yes.
thank you. Dr. Coccarella,
Yes.
okay. Ms. Montgomery,
Yes.
thank you. Dr. Feibel,
Yes.
thank you. And myself, Dr. Bechtel, yes. We'll turn now to the matter of HJMD. Do I hear a motion to ratify the proposed Step 1 consent agreement with HGMD? Do I have a motion?
So moved, Dr. Caparella.
Dr. Cockrell, Dr. Johnson, second. Thank you. Roll call, Dr. Rothermel,
Abstain.
and Dr. Safran,
Abstain.
Mr. Gaccoloni, Dr. Soin,
Yes.
and Dr. Schonstein,
Yes.
Dr. Reddy,
Yes.
Dr. Johnson,
Yes.
Dr. Coccarella.
Yes.
Thank you. Ms. Montgomery,
Yes.
thank you. Dr. Feibel,
Yes.
myself, Dr. Bechtel, yes. We'll now turn to the matter of MDC RCP. Do I hear a motion to ratify the proposed proceeding Step 1 consent agreement with MDC RCP? Do I have a motion?
So moved, Dr.
Dr.
Caparella.
Cockrell, second.
Second.
Dr. Johnson, thank you. Roll call, Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Uh-oh. Dr. Beckel, can you hear us?
We've lost our leader.
Hi, Dr. Beckel, can you hear us okay now?
okay. Dr. Safran, can you hear us?
I think he's intermittently freezing.
Yeah, Dr. Beckel, there appears to be another delay, and you had frozen for a little bit at the beginning of the roll call. And it seems better now. There's maybe a 1 second delay, but I think that's all right. Would you mind beginning the roll call again?
I will, thank you.
Thank
Dr.
you.
Rothermel,
Abstain.
Dr. Safran,
Abstain.
thank you. Mr. Gaccoloni,
Yes.
Dr. Soin,
Yes.
Dr. Schonstein,
Yes.
Dr. Reddy,
Yes.
Dr. Johnson,
Yes.
Dr. Coccarella,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
yes. And myself, Dr. Bechtel, yes. We'll now turn to the matter of ADR MD. Do I hear a motion to ratify the proposed permanent surrender with ADR MD? Do I have a motion?
So
So
moved,
moved.
Dr.
Dr.
Johnson.
Beckel, Dr. Johnson, second. Roll call vote, Dr. Rothermel,
Abstain.
Dr. Safran,
Abstain.
Mr. Gaccoloni,
Yes.
Dr. Soin,
Yes.
yes. Dr. Schonstein,
Yes.
thank you. Dr. Reddy,
Yes.
yeah. Dr. Johnson,
Yes.
thank you. Dr. Coccarella,
Yes.
yes. Ms. Montgomery,
Yes.
yes. Dr. Feibel,
Yes.
yes. And myself, Dr. Bechtel, will have to abstain in this situation. We'll now turn to the matter of ESPA. Do I hear a motion to ratify the proposed Step 1 consent agreement with ESPA? Do you have a motion?
So moved.
So
Dr.
moved.
Johnson, Dr. Cockrell, a second. Thank you. Roll call, Dr. Rothermel,
Abstain.
and Dr. Safran,
Abstain.
Okay, thank you. Mr. Gacaloni?
Yes.
Thank you. Dr. Soin?
Yes.
Yes, thank you. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson? Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Yes. Myself, Dr. Bechtel, yes. Now to the matter of HAMT. Do I hear a motion to ratify the proposed permanent surrender with AJMT? Do I have a motion?
So moved.
Dr. Carroll and Dr. Johnson second. Roll call vote, Dr. Rothermel?
Abstain.
Abstain. Dr. Safran?
Abstain.
Okay. Mr. Gacaloni?
Yes.
Thank you. Dr. Soin?
Yes.
Thank you. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Okay. Ms. Montgomery?
Yes.
Yes. Dr. Feibel?
Yes.
Yes. And myself, Dr. Bechtel, yes. And now we'll turn to our sites, our notices of opportunity for hearing, orders of summary suspension, orders of immediate suspension, and orders of automatic suspension. Ms. Marshall, would you like to present the proposed citations?
Dr. Bechtel, members of the board, thank you. We have 13 proposed citations for you this month. The first is a summary suspension. It is to be issued to a massage therapist, and it is based on a failure to go to a board-ordered substance abuse exam on April 26th. Our second citation is to be issued to a DO applicant. This is based on failure to go to a board-ordered psychiatric evaluation on March 18th. Our third notice is a summary suspension. It's to be issued to an MD. It is based on the physician receiving intervention in lieu of conviction for attempted unlawful sexual contact with a minor. Our fourth citation is to be issued to an MD. This physician is a psychiatrist, and the site alleges sexual misconduct involving one patient. Our fifth citation is to be issued to a massage therapist. It is based on violation of the terms of his probation under your June 2020 consent agreement.
I have a question on that one.
Yes, ma'am.
Rebecca, are the appearances that were scheduled, that were missed, were those scheduled for a Zoom appearance? Or
Yes, compliance is using remote appearances during the pandemic.
okay, thank you.
Our sixth citation is to be issued to an MD. It's based on felony convictions related to practice and action taken by the Illinois Medical Board. Our seventh citation is to be issued to an MD. It alleges acts constituting criminal offenses, including abduction and gross sexual imposition involving a female coworker. Our eighth citation is to be issued to an MD. It is based upon action taken by the Kentucky Medical Board.
I just wanted to say to you, Rebecca, that was very quick work on that one. Well done.
Thank you. I'll pass that along. Our ninth citation is for an MD. It's based on action by the New York Medical Board regarding anesthesia care to 4 patients.
Again, the time is great. Well done.
Our 10th citation is to be issued to an MD. It's based on action by the North Carolina Medical Board arising from the doctor's voluntary agreement not to practice there due to an indictment on sex crimes.
I have a question there, Miss.
Yes.
Rebecca, what is the standard regarding summary suspension on occasions like this when we've got what appears to be a predator? In fact, has been found to be a predator, and he is summary suspended in one state, but we are giving him a hearing on the other I don't know if he's got the capacity to practice here. We don't seem to have curbs on this one, and I'm not sure why. Should this have been a summary suspension versus a going through the normal hearing process?
Yeah, okay, so a lot to unpack there. So the legal requirement to do a summary suspension is we must have clear and convincing evidence of a violation, and we have to be able to show an immediate and serious risk of harm to patients here in Ohio. So this physician has not actually been summarily suspended by North Carolina. He's entered into a voluntary agreement not to practice, which is similar to what we offer here when people are indicted. He has not yet been determined to be a predator. He's only been charged. He's not yet had his due process. He's not has his conviction. And he also is in North Carolina. And so for those collective reasons, it was our determination, you can't satisfy the prongs at this time.
And is there any interim where we can, I think you're working on this kind of thing, interim where we can ask him to similarly, because your point is well taken, he has not been convicted, and that's true. So you can't establish that he's a pedophile, or, is he a predator yet? But the query would be, is there an interim where we could mirror or get as part of a settlement or an interim kind of proposition, or is that not existent in the law?
No, we will, in a case like this, we will consistently try to get one of those, what we call a B-34 voluntary agreement for someone not to practice here. They are often rejected. And when that happens, there isn't a lot we can do except issue an action based on the other board. And of course, if we get a conviction, we could act upon that. And if there's a subsequent order from North Carolina, we could act upon that. And if we had information indicating that he has gone from North Carolina to Ohio, then we could act upon that.
And if I may ask a follow-up question, but it's related to the summary suspension question, even in the last case that we took, where we have a standards question, and the question would be, I think they gave him a summary suspension, yes, in New York, and we didn't think that met the two-prong test.
Yeah, so in the prior site, the action who was sanctioned, the doctor who was sanctioned by New York, he has not yet had his hearing. They have not yet issued a final order to determine whether or not he actually did violate the standard of care, and he also is in New York. Okay. So again, same kind of rationale for those.
Thank you.
Yes, sir, Dr. Feibel.
Oh, I'm a little confused about the second prong, a direct immediate threat to patient safety here. He has a license to practice here, so he can come and practice anytime. Nothing stops him from practicing. So to say that he doesn't have the ability to cause patient harm, I mean, this is going to take a year to adjudicate, most likely. So he gets a job here 3 months from now and starts working here. How does that work? We can't all of a sudden summarily suspend him at that point, and we wouldn't even know he was working here. So I think we're being, I mean, again, I'm not a lawyer, so I don't know, but I think we're being a little strict with that particular prong.
I happen to agree with Jonathan in this one, Dr. Feibel, because I think if in fact there were the first prong there was an action taken based upon provable facts that have been proven or ascertained, I think that just because we have time and distance, it seems to me that once we have that completed in the other state, and it's a predatory or it's a standards issue, I think by definition, and we're bootstrapping it, it seems by definition that we have enough sufficient evidence to protect the public by taking similar activity, at least temporary action, summary action, until we sort through it in Ohio if that's necessary. I happen to agree with Dr. Feigl on that.
Yeah, so I guess, we've talked about this a number of times. I think there are always many factors when you're looking at the summary suspension. When physicians are not in Ohio, it is a much higher burden for us to meet that prong in good faith, to say that we can show there's immediate and serious risk here if we have reason to believe people are not here. So Dr. Feigl, in answer to your first question, if we did get information that someone was here, I would feel 100% comfortable in using that factor to then issue a summary suspension, because the main reason you're not summarily suspending is because they are far away and you don't have any evidence that Ohio patients are at risk in an immediate way. If that changes, then you meet the prongs and you absolutely could act.
We don't have a vehicle to know whether he's in Ohio. That's the problem. Unless statutorily or by rule, I think it had to probably be statutorily, we can get a hook. But we have no vehicle to know whether he travels from, because he's going to have no source of income, we assume. That may not be a proper assumption, but if he's not, he's precluded here, he may go in locum tenens, or he might just move here and we have no vehicle to know that unless somebody whispers it in our ear. So how do you, what do you suggest to that?
Yeah, well, they are required to notify us of their practice address within 30 days. His address of record is in New York. I've shared with you before, one of the things the Secretary and Supervising Member will look at is, if they're not in Ohio, is how far away are they? So we have a different point of view on people who are in Michigan, Indiana, West Virginia, Pennsylvania, because there you have a better supporting basis for immediacy of risk of harm to people here in Ohio. When we have a credentials address and all of our investigative information indicates they're in a state far away, like New York or North Carolina, it's going to weigh in favor of that determination. And the other thing I would add is, we all want to protect people. A very important tool in protecting people is making sure our summary suspension statute stays intact. The courts are very, very vigorous in making sure we are not killing an ant with a sledgehammer, and we have to be very responsible in how we use that. And so we do consult with our AGs, and we try to make sure that every time we are summarily suspending, we have a very good, strong basis to do that. It's not that we're afraid to do it. We just try to be responsible and balanced in how we do it. And ultimately, the way the statute is worded, it is up to your Secretary and Supervising Member, who the board elects, to make that final decision on what falls into a summary suspension and what does not.
Rebecca, yes. I agree with you. It's a death penalty. It's a death penalty matter for practice, and so I think you're very wise legally to be very cautious about the use of that. Are you saying that if he or she were, after being summarily suspended or revoked in one state, and that doc wants to come to Ohio, he's required to tell us he's practicing in Ohio?
He's required to update his residence and practice address within 30 days.
And how does he know? How does he know that if he's living in New York and we have an Ohio requirement to notify us? How does he know that?
Well, it's in the Ohio law, and you're responsible for the state where you hold a license. So, he should know it. I can't tell you whether or not he does know it, but it's there, and he's responsible for knowing it.
Yeah, I guess that's a problem. I know that ignorance of the law is no excuse, but if you're trying to protect, I think it's worthy of at least discussing at some point if there's another vehicle to build to protect this kind of situation? Just a point of view.
Sure. Dr. Schottenstein, yes, sir.
Hi, thank you. I would just say that, we're bound by the statute. The statute references imminent risk of harm and not the potential for imminent risk of harm. So either there's imminent risk of harm or there's not. And we can't, summarily suspend because one day there could be imminent risk of harm. There has to be imminent risk of harm, I think. And then to Rebecca's earlier point, I think if we get out ahead of ourselves too much with this, we take the chance that, this privilege is taken away from us. And so I feel like we have to be careful that way. I feel like I very much appreciate everybody's concerns. I think, though, that, ultimately, if this is something we feel strongly about addressing to sort of tighten it up, we need to do it with the legislature and not get out in front of ourselves.
Yeah, I agree. That's why I said if we need to think if there's another vehicle while we're preparing a legislative package, if there's something, because I think you're quite right. And I think Rebecca is very wise in saying this is a remedy we use discreetly and carefully because it's a tool that we can't afford to lose. And the courts will look carefully at it.
Dr. Reddy, I saw you had a question.
Yes, my question is regarding citation 9. So
Yes.
This gentleman is practicing in New York. Now, if I were to look up this MD's license in Ohio, would there be anything stating that there is another board outside Ohio that taking action?
Good question. So if you looked at right at this moment, you would not. But tomorrow when you look, assuming the board orders to issue this cite, it will be there that we have cited him. So people in Ohio will have notice of this, assuming you guys vote to issue this. We'll put it on the website immediately.
Thank you.
Dr. Freibel, yes, sir.
The only thing I'll say about this is, with how people travel, whether he's in West Virginia or Michigan or North Carolina or New York, probably shouldn't matter of a prong of summary suspension, in my opinion. If he's practicing in the southern part of West Virginia, it's no different than in North Carolina. So I don't think that should be part of the prong that we're using. I still have this gentleman, assuming his allegations are proven correct, this gentleman has proven that he has no regard for the law. So I think he's going to comply with telling us within 30 days that he's moved to Ohio is somewhat naive. And I just think if he comes here and somebody gets harmed in the next year, we look poor on this. He has voluntarily given up his license in North Carolina. He's agreed not to practice there. So to me, that's a different situation than somebody who has completely denied the allegations and said, I'm still practicing. He's agreed not to practice there. And I think there's no way we will know if he comes to Ohio and practices, because I don't believe that he will comply with, I have a hard time believing that if the allegations are true, he has any regard for any of the laws in any of the states. So I think it's naive to think that we're going to know within 30 days that he's in Ohio. We have no way of knowing, and he can practice here for the next year. So it does worry me, a threat to the public, and I don't, again, I'm not a lawyer, but I hope the courts would not penalize us, since our duty is to protect the public, that we are protecting the public from a child predator.
Just to follow up on that, Rebecca, I mean, if he's only licensed in Ohio and North Carolina, isn't that almost equivalent to being in an adjacent state? Isn't there an argument to be said? I mean, if he's licensed in 50 states, okay, I get it, right? But if he's only licensed in Ohio and North Carolina, process of elimination, if he isn't going to work in North Carolina, it would not be illogical for him to move to Ohio and set up shop. And therefore, does that at least meet the immediacy on?
Well, it's something certainly that the secretary and supervising member now and in all of our prior secretary and supervising members, again, lots of factors and always lots of stuff to weigh. I think there's a lot of shades of gray in many of these cases, and the secretary and supervising member, whoever holds that position, I think they have always very dutifully exercised their authority and trying to balance that protection versus overreach. And I really don't know what else to tell you other than that. We go through the process. We're very thorough. We look at all the information. We make the best decision we can make in consultation with the AGs to try and balance all those kinds of competing interests. Yes, Dr. Feibel.
The only other thing I'll say, and I'll be quiet on this afterwards, is that you say it's the secretary and supervising member who are deciding this. We're voting on this. So we're making that decision. And if we're not making, and I've been through this again before, if we're not making that decision, then we shouldn't be voting on it. But we're affirming the secretary and supervising member's decision. It is our decision to issue this site. It's not the secretary and supervising members, with all due respect to them. And I do appreciate them very much. But I think it's on each of us that we're making this decision. And it's not on the secretary and supervising member. So I don't think it's fair to say it's the secretary and supervising member's decision, because if that's the case, I'd like to abstain on this vote. Because I don't want to, I'm making this vote. So the secretary and supervising member are recommending to us what to do, but we're making the ultimate decision.
So I'll have our AGs help me out here if you'd like to hear from someone other than me. The way the statute is, the secretary and supervising member hold the legal authority to make the determination of whether or not to pursue and recommend a summary suspension. You as a board member are voting on whether or not you want to issue this citation today to pursue formal disciplinary action against this position. It's just, if you vote yes, you're voting yes, I want to pursue discipline. If you vote no or you abstain, then you're not voting to support this going forward with formal discipline. That's Mindy or Kyle, do you want to weigh in on that?
That is correct. Your analysis is correct.
Yeah, but with all due respect, if we can vote no.
We'll have the ability to issue a summary suspension in this case.
Well, but just to clarify, if we vote no, we can also ask that the secretary and supervisor reconsider whether to issue this as a summary suspension too. It's not a slam dunk. We're voting against it. We're voting against it as is, right?
So procedurally, we've never had that happen, but procedurally, if we did, then you would get no action this month. It would go back to the secretary and supervising member. They'll make a decision based on the same information they had before. And then it will be a month later coming back to you, and may very well likely be exactly what you have now, just a month older.
Well, maybe a month older, or it might be immediate suspension after they've heard the commentary from the board too. So again, I don't think it's a no or yes vote. I think it's a yes, or it's a please reconsider.
Yeah, I think, and I'd like to hear from Kyle and Mindy. I think what concerns me about this particular case is this person has only been indicted. I will never defend somebody and say, they're great because they've only been indicted, but they have not yet had their due process in the court system. Our emotional reaction, understandably, is we're all concerned. There is a certain threshold to get indicted for a sex crime, but we do not have a conviction yet. We do not even have a final order from North Carolina yet. This is all just charges at this point. Kyle and Mindy, anything to add to that?
Yeah, I'll add that, when we review these, we have to be very careful that we are putting forth something that's going to stand up in a court. And if we go before a judge and say, we have these allegations that have been made, because that's what an indictment is, no conclusive proof. Oh, and by the way, the guy is, I don't know, where is he? North Carolina. And we don't know whether he's in Ohio. I don't think that that's going to stand up, and that's just going to weaken your ability to summarily suspend. And I don't necessarily agree with the fact that people can travel and just set up camp wherever they want. I don't know what this specialty is, but I don't think that a doctor can just, be a cardiologist and come to Columbus with an indictment and start practicing at a hospital. So I don't think it's as easy as just, going from, 4 states away to set up practice and start practicing. So I just think that the board has to be really careful about the use of its summary suspension, because, if we push it, it's going to go away.
Mindy, just one comment to you. I think you raised a good point. But if his only other license is Ohio, again, if he's got multiple licenses, I'm right there with you, okay? The only license is Ohio. This guy, here's the worst case scenario. He shows up in Ohio and becomes, a rogue doctor, sets up his own shop, and then we got, forget about this, we've got a pill issue. So my concern is very limited choices, but the choices that are available to him are actually not really good. The word nefarious conduct, allegedly. And the other thing I would add on this, after this whole event with, sexual misconduct, is this the one we want to let get through the gate? Okay, if we are, that's fine. I'm seeing this, and I'm seeing, I think we have an argument here. Again, if there's multiple states, I'm there with you. But if this is the only other state, and he can't practice in North Carolina, what's the livelihood here? Was he going to work at McDonald's? I don't think so.
Well, so let me just say, there was some discussion about how you would know whether he comes to Ohio. If he comes to Ohio and starts prescribing, ORS picks that up. And again, I just don't see how somebody with an indictment who's, relinquished a license in another state can just come to Ohio and start practicing. So, I see your point, absolutely. Like, where else is he going to go? But, maybe the answer really is, he's not going to go anywhere because he's been indicted. And we'll know if he comes to Ohio because he's going to use ORS. The ORS is going to pick up those scripts.
Yeah, but you want to be looking at the ORS data after the fact, after he's prescribed a bunch of controlled substances. I read about proactive and reactive. Because right away.
Yeah, I do hear you, but it's also speculative. Now we're getting into this. What if he does this and what if he does that? When we go before a judge and we're defending a summary suspension, we can't say, well, we had this speculation, or maybe he could have done this, or maybe he could have done this. We need clear and convincing evidence that he poses risk right now.
I'm not talking about speculation. I'm talking about the logical outcome. I'm talking about if it's only Ohio and North Carolina, he can't practice. The immediacy of him practicing here, I think, becomes exponentially greater. It's almost like an adjacent state at that point.
It's also his locum tenens. I absolutely 100% agree with, we have to be very careful about the use of summary suspension. Absolutely. And Rebecca and the AAGs are absolutely right there. There is not, I think we should just talk about whether there's an interim process. For example, we know that somebody in one state has either voluntarily agreed not to practice until the ending of his conviction, or, his conviction rather than an indictment. So he's under some kind of bond requirement. Either he's an OR or he's under some bond requirement. Now, this may be asking a lot. And again, this goes back to, is there another vehicle? But if we know that, for example, in what Mr. Giacalone has outlined, he's in only 2 states. One state he's given up either voluntarily or he's been, involuntarily. We can always, I think, reach out to the state where he has given up his license to practice temporarily and ask the medical board or to seek as part of a condition of bond that should he determine that he's going to go in locum tenens or move to practice in the other state he has, in the states he has licenses, then we should ask as a condition of bond that at least notice is given to the states. So despite what the law says in each of those states, we have affirmative direct actions. I mean, there's ways in which I think we can, if we think creatively, find some bridges to get over the timing question and the fear, because I think you are absolutely right. We have to be extraordinarily careful about the use of summary suspension. So just an idea.
All right, ready to move on then? All right, our 11th citation is to be issued to a respiratory care applicant. It's based on false statements in attempting to secure a license and a history of conviction of misdemeanor of moral turpitude. Our 12th citation is to be issued to an MD with a training certificate. This one is not a summary suspension because he left his program in Ohio last year, so he's no longer here. Yes, ma'am.
What was the delay in getting this to us? When did the complaint come to us?
This complaint came in September of 2020. And I did make myself some notes because I know you don't have your timelines this month. There was quite a bit of subpoena activity on this one. And we did know that he was no longer in an Ohio training program. So we knew there was no exposure to patients here because you can't practice in a training program without an Ohio training license. So we had no risk of patient harm here. Got a little bit more time to work this one out.
And can I just ask one question on the prior one? You got past me before I got my question answered. And this is yeah, you're very good at it, but I know this sounds perhaps a little well. This resident resigned from his residency. Does this mean that he's no longer going to, I mean, is there any way to save him? Or does this mean that he's, because I don't know that he's employable without a residency. And he is not wanted to be involved in the one bite. I don't know, is there just any reach out or any way to see if we can save what looks to be a young doctor from himself, or is that just beyond our reach or our jurisdiction?
No, I think it's a good question. I mean, people now with initial impairment are monitored by OPEB under our one bite statutes and agreements. When they fall out of that, they come to the board, and then you have to address their issue. But of course, you'll have all the same recourses once it comes back to you after the hearing. So you could, get more information about what his status is. And then you could give him some kind of license with monitoring conditions. You could do a non-permanent revocation that leaves the door open for him to come back. So being cited is not the end of his career. It is just a mechanism to make sure his problem is addressed.
Thank you.
All right, last but not least, citation number 13 is to be issued to an acupuncturist. This has two issues, sexual misconduct from 2018 and holding himself out as being a physician on his website. Yes, Dr. Schottenstein.
Hi, forgive me. So if I could just scoot back to number 11, Valentine again, just briefly. Yes. There's a couple of different charges. One of them that the board is alleging, one of them is moral turpitude. Wasn't there some legislation recently that limited our ability to go to moral turpitude as an allegation?
There is some, yes, but it hasn't fully taken effect yet. What we're particularly using that for in this instance is that it's the lying about the conviction that is the core issue more than actually the conviction itself. This person is denying that this is them despite overwhelming evidence that it is them.
Oh, I support it. I just didn't know if that legislation that passed, was constraining for us.
Yeah, understood.
Thank you.
All right, that is all of my citations for today. Yes. Oh, Mr. Giacalone. Yes.
The dead horse on the number 10. My question becomes this. If we vote to reject it, ask for reconsideration for summary suspension. It gives us a month. That also gives you a month to go out to this guy and try to get an agreement with him to potentially avoid a potential summary suspension. That gives you a little bit of a incentive for him to pony up. Why can't we do that?
So I can't talk in public session about settlement. I will tell you that it is our consistent and routine approach to try that, and very often they tell us to jump off a cliff.
The difference is this time, the potential respondent here has a bit of a question. Is he going to roll the dice and assume he's going to get a pass and not get the summary suspension? Because I tell you what, if he's got to screw around with a summary suspension litigation and defense versus just taking an involuntary consent agreement, I know which one I'm taking, especially if I have no plans allegedly to come back to Ohio. That's a no-brainer.
Yeah, and I'm not trying to be difficult. I am truly I will say to you, I am happy to do whatever the board tells me to do. I do not think anything will change in this site, and you'll just be waiting months delay to get the same thing. But I'm happy to take it back if you want, and we would, and I'm not saying that to be difficult, I just want you to have that information. I don't think, based on what I know about this case, that anything is going to change. Yes, Dr. Schottenstein.
Hi, I really appreciate everybody's concerns about this. I would nonetheless urge everybody to vote to approve the citation. I think that one of the things we need to consider essentially is that optically, what this looks like is that we had this predator come our way, and we were presented with the option to cite, and we declined. And I think that we need to sort of consider sort of that first impression as opposed to sort of the subsequent explanations that we'll all be trying to make with the multiple media inquiries that potentially could follow as we're sort of trying to, fully explain ourselves. I think it's just a consideration.
I guess, Michael, the opposition, I think if we're on the record as to why we're taking this action, I don't think anybody's going to go after us, quite honestly. If anything, I think it just supports the notion that we want somebody out now. We don't want another event. This thing gets kicked on the way, and later on we find out, oh, well, where you guys been? You waited a year? I mean, I'll take that heat. I gladly take that heat because I think the converse is actually worse. Why did you go after when you had an opportunity? And we, this and that. No, we had to provide this. That doesn't play well. I think that plays actually worse.
Yeah, Mr. Giacalone, one of my concerns about this is even if the board were trying to summarily suspend, they have an expedited right to a hearing in 7 to 15 days. If we go to hearing in 7 to 15 days, all we're going to have for proof is you were indicted. You're not going to have anything to base your final action on that actually proves this person is a predator. You would be trying to take a final disciplinary action on someone's license when they have not yet been convicted of anything, and that puts the board in a very difficult position of, do you want to permanently revoke somebody who you suspect is a predator but you have no proof of? Or do you want to not be able to discipline somebody and then put them back in practice in a formal order? We've got that criminal case going on. So it might be short-term gain that puts you in a much worse position in 2 weeks.
I do think, Rebecca, you have to be, again, there was a summer suspension, if I'm correct, in March of 21, and we are here now in May of 21. You've done a wonderful job of getting this to us right away. And there is an and I'm, I spent too many years prosecuting predators, sexual predators, and I feel very strongly about that. But I also don't, I think Mr. Giacalone's and Dr. Peibel's concerns are very legitimate, but if I have to make a choice now, I would just simply say we should cite, but we should also see if there's a way you can reach out to get any kind of agreement, and see if there's a way to protect ourselves that way, protect the state.
Yes, Dr. Feibel.
I would agree with Betty on that. After hearing everything from AGs and other people, I think that's the right course of action. My hope is maybe with the Strauss legislation coming through, we can get the legislature, if not being able to suspend on an indictment, which we might not be able to get, at least if they have voluntarily given up their license to practice in another state, that we can use that as a reason to summarily or to suspend somebody legislatively. It would seem to me that would be okay if they're voluntarily doing not to practice in North Carolina, for instance. Legislature should be okay with us saying, and if you can't practice in North Carolina, we're presently not going to let you practice in Ohio for the time being. And I think that's a fair compromise that we could go to legislature with if they don't, because they may not give us the ability to summarily suspend based on indictment alone. But this is a way to get to that point in this type of case. I think we should really push that legislatively.
Thank you.
Yeah, I'd be happy to have that if we can get it. All right, thank you very much.
Yeah, thank you, Ms. Marshall.
Yep.
Do I hear a motion to approve and issue citation number 1, which is a summary suspension? Do I have a motion?
So moved.
Dr. Cockrell, second?
Second. Soin.
Excellent. Okay, thank you. Roll call, Dr. Rothermill,
Abstain.
Dr. Safran,
Abstain.
Mr. Coccoloni,
Yes.
Dr. Soin,
Yes.
Dr. Schottenstein,
Yes.
Dr. Reddy.
Yes.
Thank you. Dr. Johnson.
Yes.
Thank you. Dr. Coccarella.
Yes.
Okay, thank you. Ms. Montgomery,
Yes.
Dr. Feibel.
Yes.
Thank you. And myself, Dr. Bechtel, yes. Do I hear a motion to approve and issue citation number 3, which is a summary suspension? Do I have a motion?
So moved.
Dr. Cockrell, second? Or Dr. Soin?
Dr. Soin. But
Dr. Soin and made the motion. Dr. Cockrell, second. Thank you. Dr. Rothermill?
Abstain.
Okay. Dr. Safran?
Abstain.
Mr. Caccoloni?
Yes.
Dr. Soin?
yes.
Thank you. Dr. Schottenstein?
Yes.
Okay. Dr. Reddy?
Yes.
Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Myself, Dr. Bechtel, yes. We'll be considering citations number 7 and number 9 separately, so I, Dr. Bechtel, can abstain or vote appropriately. Would any board member like to consider any other citations separately? Okay. Do I hear a motion to approve and issue citations number 7 and number 9? Do I have a motion? Dr. Coccarella?
So moved.
A second?
Second.
Dr. Schottenstein, thank you. Roll call, Dr. Rothermill?
Abstain.
Okay. Dr. Safran?
Abstain.
Yeah. Mr. Caccoloni?
Yes.
Dr. Soin?
Yes.
Thank you. Dr. Schottenstein?
Yes.
Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Thank you. And myself, Dr. Bechtel, will have to abstain on 7 and 9. Do I hear a motion to approve and issue citations 2, 4, 5, 6, 8, and 10 through 13? Do I have a motion?
So moved, Dr. Cockrell.
A second?
Dr. Johnson.
Dr. Johnson, thank you. Roll call. Dr. Rothermill?
Abstain.
Thank you. Dr. Safran?
Abstain.
Mr. Gacaloni?
Yes.
Dr. Soin?
Yes.
Dr. Schonstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
And myself, Dr. Bechtel, yes. We'll next turn to the operations report. Ms. Stephanie Luca, the executive director, will present the operations report. Ms. Luca?
Thank you, Dr. Bechtel. Good afternoon, board members. For our operations report today, I'm going to go a little out of order here and start with a few updates that aren't specifically in the operations report. First, I wanted to do a follow-up on some of the Strauss Working Group report recommendations. There were a few lingering project tasks that we had begun but not completed. And I want to give you a quick status update on those. The first is the process of the internal audit that we have engaged with OBM to conduct. OBM being, the Office of Budget and Management. And so the Office of Internal Audit has started their process of reviewing our sexual misconduct protocol. And I've been working closely with them to provide them information and have conversation with them about that process. We expect that to wrap up by the end of June. They are assessing the protocol itself and identifying what controls we've put in place in that protocol, what risks we may still have, and of course, what gaps we may have with the protocol. And as they're doing their work, they're looking at our workflow, trying to better understand the steps within that protocol. And we'll also be looking at some of our systems requirements and kind of how the complaints move through our system. We do have a confidentiality agreement with them so that, they are obviously possibly seeing some F5 information. So we have that agreement with them to conduct the audit. And so it's going smoothly, and we expect that to wrap up by the end of the year. I don't think there will be any surprises when we come to the other side of that protocol audit. Any questions about that?
You said the end of the year. You mean by June?
I'm sorry.
End of
yes.
fiscal year?
I've been in government too long. The end of the year now occurs at the end of June. The second piece, and we'll hear a little bit more about this in our rules and policy update today, is that the CME, the continuing medical education for the duty to report, will be effective at the end of May. Accordingly, we are wrapping up our work on the duty to report video. I would just give a huge shout out to Jerica Stewart in our office for the work that she's done on that with the Department of Public Safety. We have a few stars in that video. Dr. Johnson graciously offered some time for that video. James Roach from our office also stars in the video. We have some witness testimony as well as some victim testimony, as well as some expert witness testimony presentation. And so, it's coming together well. I think that it far exceeded, the draft I have seen has far exceeded my expectations of what filming during a pandemic can look like. Because it will be something that we update regularly. I think it will be nice when we're not filming in a pandemic, and on the other side of that. But unfortunately, time has constrained us a bit. We pushed it as long as we could. I think it's going to be a great product. You will see that before it goes live, and we'll talk about that implementation a little bit in the rules and policy section. So that should be coming.
Can I ask a question, Stephanie?
Sure.
Is that a video that licensee will view upon renewal of their license, or can associations at a seminar have the licensee view that and get credit for it that way?
So I believe that it just has to be completed within the license cycle. I will follow up. I think we have a meeting next Monday actually to talk about the operational details. So we'll make sure to include that in the message when we send the video out, what the availability will be with that. But I would imagine that they would be able to watch it off cycle at any time as long as they have their proof somehow. We'll talk about that. That's a good question. Thank you. All right. 2 other quick random updates that aren't in the operations report. The first being financial disclosures. If you haven't turned in your financial disclosure, just remember that's due May 17th. You can file that directly with the Ethics Commission, and the medical board will then receive a bill for that. So we'll pay for it. You don't have to pay for it when you file it online. And then finally, outside of the report itself, we just recently had a discussion with the Attorney General's office about our outside counsel needs for next year. Kim and I participated in that meeting, and they are estimating again a $75,000 outside counsel, the potential for $75,000. We don't know that it will go that high, but the opiate litigation is ongoing. Kim has depositions upcoming. I believe the former executive director has a deposition that is upcoming, and we don't know what that will look. That's at the very end of May. We have some June activity. We don't know what that will look like heading into the next biennium. Additionally, we have some litigation relative to some legislation that has been ongoing over the past year and definitely will continue. So as you may remember, we had to go to the controlling board this year for additional funds for outside counsel. So this should help prevent that need to go to controlling board. I would just say that we are extremely mindful of this being a very high cost and don't like it any more than you do, but also find it rather unavoidable for these situations. Any questions on that?
Where possible, you are asking the AGA the AG to defend without hiring.
I'm sorry? I don't
Where
understand.
possible, we try to keep it in-house as opposed to
Absolutely. Absolutely. Yes. Great clarification. Yes, we do as much in-house as possible. And I know they already have a very full plate and they take on that additional work as well. And some of those litigation matters, our HHS folks help out. We get help sometimes from the constitutional law section. So the appellate section. So yeah, they are doing as much in-house as humanly possible. Mm-hmm. Thank you for clarifying that. For the operations report itself, we are in the process of filling some positions right now. You see those in your report. The budget update, Dr. Schottenstein will provide a more thorough financial update here in a little bit. But our revenue or our revenue is up a little. We still have about 9,000 licensees who have delayed renewal, who will need to renew by July 1st. I say that with the caveat that every year we lose about 4,000 licensees. So while the number in the system shows 9,000, it's probably more likely 5,000. We are in constant communication with those licensees to renew, with their associations. We provide updates to their associations to push out to their members. And we are, again, reminding people that renewing now will help them avoid some systems failures that will likely happen when hundreds of thousands of licensees around the state go to renew on June 30th. So we are hoping that our licensees avoid that. We believe we have done everything we can to save them from that fate. We'll see. I would be one of those people on June 30th. I will just tell you that. A licensure staff is extremely busy with training certificates. In fact, we think this may be the busiest they've been in a very long time. They're still continuing to do a great job working from home. But obviously licensure processing time has slowed down a little bit given the hundreds of of training certificates that they've received over the past couple of weeks. We think it's at an all-time high. We'll have some numbers when we complete this season. Project management updates. One thing I wanted to highlight in the project management update is some work that we're doing relative to our Salesforce system. We don't really have standard documentation that any employee or frankly a board member, if they're using Salesforce, can use to work in the system. So we've had some folks spending some time doing what we call job aids and process flow and really working to document that so that we have a better employee onboarding and actually have a little more standardization in our use of the system. That's as we are developing new things in Salesforce, that's a must-have right from the outset is you have to have your documentation done as to how the system will be used, how it will be rolled out to employees, and how we're going to make sure that they're using the system consistently. So we think that consistency will save some time as things are being processed. As always, communication remains very busy, processing as well as our constituent inquiries group, receiving probably between 50 to 100 emails a week from questions from our stakeholders that Jill Reardon's been handling all of those. And finally, I would just note that we continue to receive record numbers of complaints. Our open complaints continue to increase. We are closing well, and as you've seen from our sites and settlement and enforcement activity, we are moving things through. We are just continuing to take on many more complaints. We are hopeful that some of the revisions of the licensure questions that you all approved a few months ago may actually cut down on some open complaints coming out of licensure. And as was alluded to earlier, we're also looking for every tool in the toolbox that we can use to give ourselves some options between that idea of no action versus the full throttle public enforcement. So we're looking at what other states are doing. We're looking to the FSMB and in conversation even with our AAGs about this, how can we get to resolution and help our licensees be more successful and close more of those complaints faster. That is my full report. I'm happy to answer any questions. Yes, Ms. Montgomery.
Well, first of all, a shout out to the staff. I mean, these last couple of meetings have been very productive, and to everyone, you know, we're seeing productivity and the massive amount of work that you're trying to get done, both behind the scenes and then the public face. It's been a delight to watch, and congratulations to you as leader for doing that. A question was raised appropriately several times by Dr. Soin about permanent surrender and our process and perhaps our training and our template or some way to establish that our process is fair and not subject to the criticism that might come with, bullying them into. I think it's a very, very, very appropriate personally. And I just wondered where we were on that.
Sure. Thanks for the question and the observation from Dr. Soin. So, and I think others shared that as well. So we have been looking at our surrender and frankly, all of our board action data over the past 2 years. And so I'm working with that data now to look at kind of what were the underlying allegations, how did we get to surrender or revocation or whatever that looked like, what processes were followed along the way, and actually doing some of my own internal kind of random auditing of the steps that were followed with all of our staff members along the way. I can share with you that to date, I have not seen anything alarming. In fact, I listened to an investigation the other day, one of our investigators who I actually stopped and thought to myself, we actually almost tried to prevent the surrender by reminding of the licensee's need to slow down, take a breath, go talk to your lawyers. We won't do this with you today. We want you to talk to your lawyers and seek that counsel before we will have that discussion with you. Now, certainly, I've not listened to every investigation and or read every surrender in detail, but I can share with you that I believe there are about 30 over the past 2 years that I've looked at. I haven't seen anything alarming to date, but it is something we take extremely seriously and are looking for system documentation and protocols to follow in the event of a surrender. We certainly want our licensees to be successful, and if that means a discipline can get them back onto being success, we want that for them. If it's a very egregious public safety situation, then that surrender is something we will gladly take. We're also constantly balancing the need to preserve the agency's future litigation. And if we do something and that surrender really is a surefire way that we do avoid that appeal and that litigation, and that's something that when we're looking at the public safety risk, that's something that we're weighing when we're thinking about that public safety.
If I may, since Betty brought up my name, I have two questions, I suppose, for you, Stephanie, or perhaps a comment more than a question. One is, I want to make clear one thing to everyone involved in the process of negotiating a permanent surrender, and that is, to some extent, you guys do speak for me, but to some extent, you don't. So, for example, if it's something so egregious where someone's life is in danger, molestation of a child or something like that, I mean, clearly, that's pretty clear cut to me. But what I would dislike is if a comment is made to a licensee in the order of, if you pursue this, the board's just going to take your license away anyways, and it's going to be embarrassing for you. I don't know if that's accurate, because you guys actually don't know what we're going to do. I literally don't know what we're going to do sometimes until these are discussed. And I would think I want to make that point. The second is, do you have comparative data on how Ohio is regarding permanent surrenders compared to other states? Because if we are an outlier, I think that could potentially show that maybe we are doing things differently than other states, and maybe there are potentially room for improvement. I remember when AJ was executive director, he had made a comment on how we were one of the top states in citing doctors as if that was a badge of honor. But I think if you're an outlier in something like that, I don't actually know what the truth is. So do you know where we are in regards to permanent surrenders? It seems to be 40 to 50% or more of the actions that I see over the past couple of months, including this month and last.
Right. So I'll go backwards in order of your questions. So with respect to where we compare to other jurisdictions, I do not know that. I would completely agree with your sentiment that our goal is not to, my goal is not to say that success is a measure of, discipline is a measure of success. I actually think that a measure of success would be seeing less complaints and leading to less discipline. That means we're doing our job as a regulatory board to educate licensees. So I take that, I think I completely agree with that. That's something we can definitely look into and we'll follow up on, is how we compare to other states, with the caveat that as we've done other state research, something that we have noted is we're looking at sort of that intermediate sanction, what I call an intermediate sanction option. Instead of going for that full enforcement activity, the tools in the toolboxes vary so drastically by state, right? So right now we have limited options, and I think that's a real challenge for us. And what we're finding that we do like in other states is some states do have those other options. So consequently, they may not have as many surrenders. But I think it's certainly something we can look at. And if they don't, are those other tools maybe more successful in those states? So that's, kind of, I would say one of our bigger focuses going over the next year is thinking through what is available to us for enforcement activity. And I would imagine that we would see less of those going forward. So we'll follow up on the other state comparison and bring that back along with some of our own data. I think probably June, maybe July. The second question, with respect to speaking on behalf of the board, I think that's a fair comment as well, and one that we can take back to staff. It is my mantra here that we never presume the activity of the board. In fact, we had a media statement prepared the other day that said the board will vote on X matter tomorrow at the meeting. And I had them revise it to say the board is expected to vote. I certainly, every board meeting is an adventure. I certainly never presume to assume how you will vote on a matter or what your thoughts would be on discipline. I think we've had quite a few reports and recommendations revised this year, where you look at what the hearing officers have provided to you, and you as a board have had a really robust discussion and even revised those recommendations. So, maybe we can talk offline if you're hearing concerns from colleagues about that sort of presentation. I have not encountered that, but I will certainly be mindful of it and send that message to staff. I 100% agree with that. We are not speaking on behalf of what the board will do in the future.
Oh, I do want to make it clear that I didn't hear anything from staff that was concerning to me. That was just my own personal assessment, and it may be false or incorrect. But I have heard people say that, they want to avoid, sometimes it's a mechanism to avoid embarrassment, et cetera. I don't know what's embarrassing to one person or what's not, or if that's even productive to, because at some point I wonder if it's coercive. I'd hate to do that to somebody. I don't know.
Stephanie, I agree with them all. Unless there's precedent as to us pulling the license, I don't think that ever should come out. I mean, the case should be right on point, right? I mean, the board's done there in this situation. It shouldn't be, speculative. I agree. And I'm not saying that's the case. I'm just saying if they're going to play that card, it better be substantiated. Secondly, when we look at statistics, we got to be careful here, because my concern is we've seen a lot of cases come in from other states where they don't do anything, or they slap somebody on the wrist, and then we take a more affirmative action. I can think of one where there was a physician who was with a stripper giving her drugs, and they let that state let him go through the gate. Okay. And
we had one today too, Bob.
I'm sorry?
We had one today too that we confronted.
Exactly. So I think we just better be real careful, because honestly, if that's the bar, I'm happy to be above that bar in terms of discipline, because where my concern, that's just, that's protecting your own, and that's not what we're in the business of here. So again, I'm more than happy to look at statistics, but without some granularity as to what those cases are, I'm going to take it with a big grain of salt.
Right. And I think that, to my earlier point, I think that granularity is important, because again, not only is it just the boards themselves, right? We've heard of other states that I don't know why they even have boards. And then also that, again, the mechanisms that they have available to them might not be an apples to apples comparison. So when we look at that, I think that granularity is important.
Yeah, and I do want to say I do agree with Bob on that. Statistics can be incredibly misleading. But for me, I just have no concept of what goes on in other states. And I guess it would just be a little helpful to know it. I honestly, I know everyone does good work and has their best interest in mind. But to Bob's point, it's such a complicated issue, right? Because it's tough to say you should never say we're going to revoke your license. But like if you
received really positive feedback from licensees, from associations, and even from our own staff members that they really enjoy watching the meetings. Because they're hearing conversations like this, right? And I think that's very educational for them to hear the board and to understand how the board process works. So in the spirit of transparency, we would really like to continue to stream them. We have some technology limitations, but we're working through those. Some of it is relative to our hearing room and that not belonging to us. It belongs to Department of Administrative Services. So we'll be working with them to see if we can come up with some technology options for that. I don't have an exact date for a return in person. I'm hopeful maybe something will happen by June. So we will certainly keep you posted, and we'll have to know that very soon so that you all can plan. We recognize that as well. The law that allows us to meet remotely expires as of July 1st. And so we will certainly, unless that law changes again, we have no indications that it will, actually the contrary, we will be back in person in July.
So Stephanie, will we have, if that's the case, will we have a retreat this summer?
So we haven't planned that yet, but I think that, our last retreat was in October. It would be really fantastic to be able to pull back together in person or something like that. Retreats, and this is not any, obviously we're here to do our jobs, but retreats do take a lot of time and planning. So we'll need to know a few months out for that, just relative to presentation purposes and kind of building those in. So I would speculate early fall. If we want to explore a retreat again in early fall, I think that would be a good time.
Thank you.
Sure. Any other questions for me? I would just kind of wrap up my operations report, and I know we still have more board matters to go, but I don't want this to go without notice. So Dr. Bechtel is in his 60-day extension on his seat right now, and we have not heard any word on the appointment process for Dr. Bechtel's seat. And so I hate that we're doing this via Zoom, and it may be not necessary to do it if we hear of a reappointment, but I also didn't want the moment to go by where we didn't take a moment, if this is Dr. Bechtel's last meeting, to be able to say thank you to him. And also to note that if it is his last meeting, what we would like to do is, when we are in person, have a board lunch where we can in person properly thank him and award him for all of his services. But so it would feel wrong to have a meeting in June without him on, without some sort of acknowledgement, if that is to be the case.
So would it be best for us to say, we don't want to say goodbye to you, Dr. Bechtel, so we're all keeping our fingers crossed, but it's just been a pleasure serving with you. You are a remarkable human being as well as a remarkable doctor.
It's been such a tremendous honor working with all of you and many of you many years with such professionalism and integrity and really true concern for the safety of our public. And you worked so hard, and it's been a tremendous honor, and we'll see what happens. Thank you.
I've always said you're the smartest doctor I know, so you can't go anywhere. We need you on here. So,
yeah, it'll break my heart if you're not reappointed. It's a pleasure serving with you.
Yeah, Mark, it's the same thing. And you know what? Maybe if you go to the restroom, they'll come back and reappoint you. So
I was thinking about that.
Thanks so much, Mark.
It's been an honor to work with you, Dr. Bechtel.
Right. Thank you, Bruce.
All right, Dr. Bechtel, that concludes my operations report.
Thank you, Ms. Luca. Ms. Anderson, now we'll discuss the rules review update.
Thank you. So you have the materials about the update on our rules. We do have several rules that have come out of CSI, and I'm waiting to file with JCAR. So we have the delegation rules, the sexual misconduct rules, and prescribing to family and self were released from CSI after our last board meeting. We also have Rule 4731-605 that you approved on attempt limits for examinations, and that is still out for initial circulation until next Monday. So I'll be coming back to you next month with anything that we have received for that. We also have a rules hearing scheduled for Monday on the hearing rules, 3 dietetics rules, and our light-based rules, our permanent light-based rules. which we need to get in place because of the emergency rule expiration in early August for the cosmetic therapists. So that's kind of just an overview of some changes since last time. And then if you're ready, we have a number of rules to finally adopt. And I can move on to that, Dr. Bechtel, if that's okay. Okay, thank you. So you have a memo from me with a number of rules regarding confidential personal information, our CME rules, and rules related to exposure-prone invasive procedures, a licensure rule for temporary licensure for members of the military and spouses who are licensed in another jurisdiction, which implements a Senate bill from last year, and some updates to radiologist assistant rules as well. So these rules are all ready for adoption. I think we've talked a little bit about new rule 473110-02, which is a CME rule for physicians, and it does require a minimum of 1 hour CME approved by the board on the topic of a licensee's duty to report. So that's in Rule 1002. So the motion that we have would be to approve, adopt, amend, and rescind the rules, and to assign the effective date of May 31st, which is the last day of this month, for those rules. But for Rule 473110-02 and the duty to report video, we would ask that the motion includes that enforcement of that provision will commence for licensees submitting their renewal applications on or after July 1, 2021, to give people a bit of time on that particular provision.
So do I have a motion to support Kim's proposal, Ms. Anderson's proposal? So moved. Okay. Moved by Dr. Johnson, second by Dr. Coccarella. All in favor, say aye.
Aye.
Aye. Opposed?
Aye.
The motion carries. Thank you, Ms. Anderson.
Thank you. I can move on and talk a bit about the memo that you have on rule revisions. This is rule revisions required by House Bill 442, which made a number of changes to massage therapy curriculum, and also eliminated licensure of cosmetic therapists and oriental medicine practitioners. So we've got a little bit of a grab bag here in this memo, in this rule package. So we're making the updates for House Bill 442, but we're also doing a rewrite of the massage therapy section. So some of those rules are up for 5-year review right now. Joe Turek, our Deputy Director for Licensure, has gone through these rules and made a number of updates, especially related to limited branch schools for approval to update and streamline those rules. I will let you know that we have been having discussions with the massage therapy associations and the schools. Jill Reardon and Chelsea Wansky have been assisting with that. And we have received some comments from massage therapy schools. We received a number of comments about a proposed revision to 4731-1-15 about the definition of clock hours. And we have taken that comment into account. And the version that you see does reflect those comments from the schools. that an hour means a period of 60 minutes with a minimum of 50 minutes of instruction. So that is coming to you based on some of the feedback that we received from the massage therapy schools. In addition to the massage therapy rules, we are also proposing some changes. The 4731-2207, which is emeritus status, and we're just proposing to delete the reference to cosmetic therapists. 473130-03, which is our internal management rule for approval of licensure applications. And we need to delete the reference to Oriental medicine practitioner in that rule. And then 473136-01, military provisions related to education and experience requirements for licensure. And we need to delete reference to cosmetic therapists and Oriental medicine practitioners. What we are asking for you to do is just approve those for initial circulation, and we'll continue to get feedback.
Dr. Schottenstein?
Hi, thank you so much. So looking again at 4731-1-15, B4, right? Paragraph B4, one of the criteria for a person seeking a license to practice massage therapy in Ohio is that they're in the 5-year period immediately preceding the date of application be a current, license or registration in another state. And I guess what I was thinking as I was reading that is, gosh, 5 years is kind of a long time. And I was wondering, if that had ever come up as to whether or not maybe we'd be right to, shorten that, right? Because I guess I'm wondering if there are a lot of qualified, potential candidates who are not able to practice because they don't quite meet that 5-year rule. I guess I wonder how much additional benefit we're getting by, holding on to years 3 through 5 or 4 and 5, and if we'd be right to shorten that. I don't know if anybody from licensure is here with us to potentially weigh on that, or just how everybody feels about that.
So I can talk a little bit about that. I think we have talked about doing that in the past. I am not 100% sure, and Mitch may be able to help me. There may be a statutory requirement, but that's something we would need to check. I'm not 100% sure about that.
Thank you, Dr. Schottenstein. It has come up in the past as a possible way to improve the process. As far as, more specifically what we would like to do, like make it 2 years instead of 5, or, anything along those lines, it's up for discussion. So that's a very good, idea. But I definitely would have to talk with Joe, get some more information as far as where we are with it.
Do you have a sense, Mitch, as to what other states do? And I'm just sort of curious if that 5 years is ballpark or an outlier compared to other states' requirements.
I do not have a current sense, but I would. I'm confident, at least guessing, if that's a good phrase to use, that 5 years seems to be a bit much in today's world. So we can definitely, find out more information for you and get back with you.
I'd agree with Michael. I think 5 years is overkill on this one for a massage therapist. And I don't know if it is statutory, Mitch. Do you know for a fact? Is it not statutory? Is it rules that we made for the 5 years?
I believe, I'll have to double check, but I believe it's rule. No, I'm not 100% sure. But,
right now, they're looking to change the massage therapy rule to require licensure. Now's the time to change it if it's statutory. Get back to them and tell them that sooner rather than later. This rule,
right?
I agree with it. It's ridiculous for massage therapists.
It's a long time.
Yeah, 5 years is a long time. So, okay. Thank you.
Thank you kindly. So on that note then, Kim, if we were inclined to explore that further, do we table this or can we, make the motion and come back to it? How would that work?
So it looks to me as though it is statutory in 473119. So if we were going to make a change here, we would have to make a statutory change.
So we could put it in our legislative bucket that Chelsea and Stephanie will be filling.
Mm-hmm. Right. And if you change the statute, it has the impact of, that changes it.
So is the marching orders here to have Chelsea go out and approach legislature and the massage therapy group and tell them we're interested in reducing it? Because there's a timeline here, right? You can't just keep sitting on this. So is that the consensus? I'm for it, but I don't know where. I think Michael's for it. I'm just not sure where everybody else stands. And also, what's the right number? 2 years. I don't care. It's got to be south of 5. A little bit 3. 2.
Right. I'd like to move forward with these rules as right. Is. I mean, we will receive. If we have your vote today, we'll send them out for initial review and we'll gather comments. And then I think if there is a consensus on the number of years you would like, or if you would like us to come back with information for legislation about what other states do, and then you can make a decision on that.
Let's do that, please. This is in statute. There's no point in holding on.
Rules, and then we'll take that information and do some research and come back on the statutory change.
One other thing, Kim, if Chelsea or someone could approach the Massage Therapy Association to figure out where they stand on this, so we're not running contrary to them, that might be helpful too.
That's a great idea. Mm-hmm.
Good.
Do you need a formal motion?
A motion, and I neglected to put it on your memo, I think. But I need a motion to approve these rules as drafted for initial circulation.
Do I have a motion, please?
So, Dr.
Coccarello. Ms. Montgomery, second?
Second.
Dr. Johnson, thank you. Do we need a voice vote on that then?
A voice vote will do.
Okay. All in favor say aye.
Aye.
Opposed? The motion carries.
Right. Thank you.
Any further business, Ms. Anderson, or is that?
I think now I'm going to turn it over to Nate Smith to talk to you about House Bill 263.
Okay, Mr. Smith.
Thank you, Dr. Bechtel and members of the board. In your materials, you have a memo on House Bill 263. This bill was signed into law on January 9th, and it requires all licensing authorities to establish by October 9th a list of criminal offenses for which a conviction, judicial finding of guilt, or plea of guilty may disqualify an individual from obtaining a license. So when reviewing an initial license application after October 9th, the licensing authority may only consider criminal offenses that are on this list. And this list of offenses will be time limited for the most part, with the exception of offenses of violence and sexually oriented offenses. Part of the licensing authority considering the offenses on the list is they are not considering the offense in isolation, but considering them with the factors such as the nature and seriousness of the offense, or whether the denial of the license is reasonably necessary to protect the public, and several other factors listed in your memo. The statute requires that the licensing authority shall include on its list offenses that are directly related to the duties and responsibility of the licensed occupations. So under the mandates of the statute, board staff met sort of across areas of the board, from the investigation, employees from investigation, enforcement, hearing unit, licensure, and legal, reviewed all of the criminal statutes in chapters 2903 through 2927, I believe, and in various other parts of the Ohio Revised Code, as well as board records on previous discipline by the board related to convictions, and have come up, have been able to compose a list. We've also spoken with representatives from the nursing board and the pharmacy board to talk to them about some considerations that went into their making of their list as well. And so attached to the memo is a list that we are asking the board at today's meeting to give some initial feedback on the list, and board staff will then incorporate any feedback you would give, and then we'll continue to refine the list. And the thought is that we'll bring the list back to you for your consideration, likely at the September board meeting. We need to have the list approved and published on the board's website per the statute by October 9th. So with that, I'm happy to I guess launch the discussion of this, take any comments that you have, answer any questions that you have regarding the draft list in the memo. Dr. Schottenstein.
Thank you. Does this list have like an elastic clause? Like, are we able to add and subtract things from the list as we go, or at some point it is what it is?
That's I'm very glad you brought up that question. I'm remiss that I didn't mention it early on. Part of what we will be coming back to you later in the summer or in early fall is what we imagine to be a rule, and it will likely be an internal management rule that will enable the board to take on a periodic review of the list. We're examining, or we're currently contemplating somewhere between an annual review or maybe a biannual review, but it would be a periodic review, and then pursuant to that review, the board could there would be provisions within that internal management rule to be able to amend the list. So the list itself is not static and forever. It can be amended and reactionary to statutory changes as the legislature adds and subtracts crimes through bills that pass during the General Assembly.
Okay. I guess, and you'll forgive me, I don't mean to get into the weeds, but could you ever envision a situation where we could have almost like an ex post facto situation, where somebody comes to us as an applicant or a licensee comes to us and we have a real concern about behavior and the concern is not on our list? Would we be able to retroactively add it at that point?
I think that's probably something we would want to talk to our AAGs about. I think that we would consider to be the best course of action to do as we have done and to examine the criminal code as comprehensively as possible and include offenses that we feel that the board may want to consider along with the factors listed in the statute, so that it gives the power for the board to consider as many offenses as would be related to the occupations. But I think that we would be hoping that with something like an annual review, we would be catching many of these situations. I think as Ms. Montgomery could certainly attest to, you would have, say if you had a new statute that passed with a new criminal offense, usually that's going to be effective, 90 days after it passes. Then someone has to actually commit the offense right after, it's occurred. That person then has to get indicted and charged and get a trial date and get convicted. And so our thought is that having that annual review period would build in the ability of the board to be able to catch things like that and make sure that we don't have a situation where we're forced to be looking at some kind of post facto retroactive application, which I think is certainly we would talk with our AAGs, but it is certainly not the position we would would not be our most favorable position.
Thank you so much.
Ms. Montgomery?
Nathan, I think you've just done a really wonderful job, you and the committee. I told you that earlier this morning. It's an exhaustive job, and I think you've delved into all of the codes outside of 29, where there are criminal penalties stuck in other sections. I don't know how you did that, but I assume you've gone through all that exhaustive process, correct?
That's correct. I'd like to name certain people. I think that James Roach and Rebecca Marshall, Angie Canepa, Kim Lee, Chelsea Wansky. I feel like I'm at the Oscars. I'm going to forget someone, but there were a lot of people who just did a wonderful job, and it was an exhaustive process, and we went statute by statute. So,
may I ask, in your speaking about getting in the weeds, but in your memo, you have one section that says penalty waterways and watercraft. I'm assuming that's a DUI operating, or what is that section referring to? Do you recall? So it's interesting because just a little bit ago in our meeting, there was a reference to a disciplinary action that you all have had within the last couple of years where someone had a few drinks, without getting into all specifics, and hit someone in his boat and drove away. And the reason that the statute was included in this is it was a statute that the board had previously disciplined. It occurred within the last couple of years, I believe. Mm-hmm. So is that covering operating a watercraft while under the influence, or is that covering leaving the scene of an accident, or both?
I think it's covering a variety of offenses within that penalty, but it includes leaving the scene of the accident, and as well as, I believe, the intoxicated operation of the boat as well.
Thank you.
Hey, Nate.
Yes.
Hey, just a clarifying question. This gigantic list, everything is on this list is going to be a disqualifying factor, correct?
So what this allows you to do is this allows the board to consider,
right,
should we get an application with somebody who has been convicted of this crime? For most of them, the person would have to have had the conviction within the last 5 years.
Okay.
So the conviction falls within the time frame, and it's on the list. The board may consider it along with, I believe, the 5 factors that were listed on the memo, and the board would have to make findings as related to those factors if they would ultimately decide to deny the license after consideration of the criminal offense in totality with those other factors.
Okay, and then the offense of violence and sexually oriented offenses are beyond the 5-year pale? Is that what's going on here?
Correct. There is no time limit on those offenses. So if you've got somebody who had a murder 20 years ago, the board can consider those 5 factors along with the murder conviction and deny, and if the board saw fit, deny the application for a murder conviction that occurred 20 years ago.
Right. So arguably, if somebody pled down to reckless homicide for murder, they would get the 5-year benefit, right? Because that's not an OV SSO, like involuntary manslaughter is. Voluntary manslaughter is. Murder is. Reckless homicide is not. Negligent homicide is not. So technically, if they got a good lawyer, pled down, they would escape the 5-year window.
Right. And so without getting too into the weeds, because it gets pretty complicated, it's 5 years from the time of conviction. But if a person has been incarcerated, say the person did, 5 years on a reckless homicide, it would be 5 years after release from incarceration. So you'd be looking at a total of probably 10 years.
Okay,
so
got it.
So,
Nate, is that release from incarceration or release from probation? I mean, because you're incarcerated, you may have community control afterwards. So is it when they're completely released from government oversight?
So there are additional provisions related to post-release control after incarceration. So it gets pretty complicated, but in essence, if someone's served prison time and then been put on post-release control, you'll be tacking on additional time. So, I think the board can take some comfort in the fact for offenses of violence and sexually oriented offenses, we have a pretty unlimited look back, and that for offenses where someone has served some serious prison time and then been put on a period of, oftentimes it's 5 years post-release control, you'll have some additional time added to that. But the calculations for the different iterations and scenarios, the way the statute is written, can get pretty complicated.
Okay, thanks.
Thank you, Mr. Smith. Ms. Wonsky, you want to provide the legislative update?
Good afternoon, Dr. Bechtel and members of the board. Thank you for the opportunity to provide an update on legislative matters currently impacting the State Medical Board. Our biggest priorities currently remain the budget and the Interstate Medical Licensure Compact. We continue to closely monitor various other bills that could have an impact on the medical board. House Bill 110, the state operating budget, was passed out of the House and is now under review in the Senate committee process. As previously mentioned last month, our initial budget request, which was granted in the executive version of the budget, remained unchanged in the House passed version. Stephanie provided testimony before the Senate Health Committee regarding the medical board appropriation after the last board meeting at the end of April. We are now waiting for the Senate substitute bill, which is expected as early as next week. The first House hearing for Senate Bill 6 is scheduled for tomorrow in the Families, Aging, and Human Services Committee. As you recall, Senate Bill 6 would require Ohio to join the Interstate Medical Licensure Compact. In the past few months, Stephanie and I have met with the bill sponsor and co-sponsor to continue to reiterate that this language will provide operational challenges and could slow the process to licensure for out-of-state applicants coming to Ohio through the compact. It is also important to note, and as I mention every single month, this language the compact language is a contract and cannot be changed. The Senate passed the Senate passed version of the bill included our amendment request to extend the implementation timeline from 6 months to 1 year, and also provides appropriation for startup costs. House Bill 37 was passed out of the House last week and would allow a pharmacist to dispense certain drugs up to 3 times within a 12-month period without a prescription. Currently, statute allows for emergency prescriptions to only be filled once. This bill is currently awaiting a first hearing in the Senate. House Bill 176 was also recently passed out of the House and now awaits its first hearing in the Senate. This bill would allow athletic trainers to enter into a collaborative agreement with a physician, a podiatrist, and also expand their services under that agreement. House Bill 122 would permit specified healthcare professionals to provide telehealth services. This language requires telehealth services be done in accordance with specified conditions and standards. The language is nearly identical to House Bill 679 from the last General Assembly. The bill was passed out of the House and is now awaiting its first hearing in the Senate Health Committee. Senate Bill 131 and House Bill 203 are both occupational licensing bills and would require an occupational licensing authority to to issue a license or provide government certifications to an applicant who currently holds a license, government certification, or private certification in another state. The two bills are very similar and nearly identical to language we saw in the last General Assembly in Senate Bill 246. We have looked through this language extensively, and we are working with the interested parties and stakeholders on concerns with this. House Bill 203 has had 2 hearings in the House State and Local Government Committee. Senate Bill 131 has not had a hearing yet. Finally, please note that there was an error on the legislative summary document. House Bill 43 on page 7 had the wrong description and also the wrong board position. A corrected version of the document is now available in the board meeting materials. And that concludes the legislative update, and I'm happy to answer any questions.
Thank you, Ms. Wansky.
Thank you.
Ms. Reardon, would you now give the Dietetics Advisory Report?
Dr. Bechtel, if I may, may I just offer one last update to the board under the legislative and policy section? So we have just this week, Kim Anderson was invited to present to the Joint Committee on Agency Rule Review, JCAR. And the question before JCAR this week was whether or not the state medical board exceeded our authority by sending a letter to Daniel Logan back in June of 2019, I believe it was. It predates me a little, so bear with me on my storytelling. So the question from JCAR was whether or not we exceeded our authority by sending that letter via a policy decision instead of going through the rulemaking process. So as you may remember, the board sent that letter in June. Dr. Logan had posed 5 questions to the board. The board answered those questions relative to the scope of his podiatric practice. And then shortly thereafter, we received a call from JCAR telling us that this may be flagged for violation of our authority to do something, that we should have been doing something by rule instead of policy. Predating that decision, a law had been enacted by the General Assembly whereby they have the authority now to call into question these executive actions in front of JCAR. So long story short, that 2018 law permits JCAR to bring agencies in and question their executive actions and say to the agencies, you will make a rule instead of doing this by policy. They can invalidate the policy decision and ask for a rule to be made or require a rule to be made. This was the first hearing that they've done under that statute. And the 2 agencies before JCAR this week were the Ohio Department of Education and the State Medical Board of Ohio. So Kim presented testimony whereby she outlined the process that the board went through and how they came to the decision to issue the letter. And the chair of the committee, there were multiple questions about the process. It was very clear throughout the process from the questions that were being asked that the JCAR members believe that we should have done a rule instead of going by policy. That being said, they did not take a vote at this committee meeting. Again, this was their first committee, and they were sort of feeling their way through the application of this new statute. And were very respectful to us and to education as they were doing this. But they're clearly figuring out how to operationalize that law. The questions were clear that they think this should have been in rule, and following the meeting, we did have some conversation with the chair, and he indicated to us that he would prefer that we do this by rule and that they not have to make us do this by rule. And so we are not here today to talk about the merits of the letter and to revisit that. However, what we are here today is to ask for the board's permission to go back to JCAR and say to them that we will engage in the rulemaking process relative to this issue, relative to the issues that were posed in Dr. Logan's letter, and Kim may be able to provide more specific reminders on what those 2 specific issues were, if you don't remember, and we can talk about that. But what we would like to do is engage in the rulemaking process. The tone of the committee is clear that and this was clear in both the education questions as well as in the state medical board questions, that there is concern on executive overreach and that this is the attempt of the legislature not to play gotcha, but to bring balance back to actions by executive agencies, and that where there is clear division between stakeholders, that the preferred path is always going to be a rule, because the legislature would like to offer those stakeholders a formal process that they can engage in. And while we may end up in the same result, where in this situation, for lack of a better description, you have a winner and a loser, that same result may happen in the JCAR process. However, the legislature feels strongly that we've then provided a formal process for stakeholders to engage in, and they are able to see all of that testimony through that formal stakeholder process. That was the clear message that was delivered to us at the meeting. And I would just say that Kim did a fantastic job with this. This was really difficult. And obviously being one of the first agencies called before them wasn't pleasant. And she did handle it really well and represented the board tremendously well. And, just really was really respectful about the whole process and painted the board very well. So my ask to all of you is that we proceed with the rulemaking process. I'm happy to take any questions or concerns. I'm sure there are some. Yes, Dr. Saffron.
Yeah, I have a question in the sense of what rule are they looking for? Because what we did was we answered a question from a doctor as it pertained to the scope of practice. Now, our scope of practice is already defined in a rule, 4731-20-02, surgery ankle joint. So it's already a rule, and we answered his question as to whether each procedure was within the rule or the scope of practice. And are they going to create a whole new scope of practice? I'm asking because I don't really understand.
Sure. So I think that one of the things that Kim pointed out to them is that we do not delineate every scope of practice. It would be impossible to list out every bit of every detail of every scope of practice in our rules. However, what they did indicate to us was when we have this question of whether or not something is a scope of practice, instead of us deciding by policy that it is, in a situation like this where there are two very differing opinions, that instead of making a policy determination, we should be proposing that as a rule. So in other words, the question you asked was how would that look in a rule? The rule would look like the affirmative answer of yes. We would create a rule that spells out the yes. And essentially you may do this because of this rule, right? So I think about I'm trying to think of a good example. Our cosmetic therapist, for example, they used to be able to do laser hair removal by rule. It's the delegation of the ability to do something by rule. And the legislature believe we did that by policy. Or we think that's what they will believe, what they believe. We have not had a final vote from them yet.
So having this rule already and us defining whether it fit into that rule, aren't we doing apples and apples here?
No, because what we haven't done in the rule is specify what they're looking for in specificity.
But then you're listing every possible procedure under.
And so I would say to you, I think the legislature's, it's an interesting question before us. And I think that they share in that thought of how does this look going forward? Because when you do start listing things out, what do you do about the things you haven't listed out? And what is within scope, what is without scope? I think that we really have to have some conversations. And again, this is all the very front line of this. We'll have to have real conversations with other regulatory boards, with the legislature going forward, I would certainly say that from a regulatory perspective, I think that it's sort of a new day. The legislature is extremely interested in what regulatory bodies are doing right now. And where we maybe didn't specify things by rule before, we might be asked to specify things going forward. What does that do for all of the stuff that's not in rule? I think it's a fair question. I don't have a great answer for that. And I don't know that anyone has a good answer for that. I think it's a to be determined.
So Stephanie, essentially, if we ever give an advisory opinion and anybody ever challenges it, all of a sudden it gets defaulted to a rule. I mean, we're never going to issue an advisory opinion if that's the case. I mean, this meets the purpose of any regulatory agency providing any guidance to its regulatory, its regulated group. I mean, I understand, and trust me, I am sensitive to overreach by agencies and lack of rule creation, but this gets to be, now we've swung the pendulum the other way. And I think honestly that's not a good thing.
Yeah, Bob, I think that's Mr. Jackley, that's a great point, and one I think that we're concerned about with respect to how do we offer advice going forward. Here's what I worry about being in a game of gotcha with our licensees, right? We certainly don't want to be in the position where a licensee asks us a question and we're not able to answer because we can't quickly go through a JCAR process, right? We want to be able to give them good advice so they don't find themselves in an enforcement situation. That's frequently a tricky question anyway, and we do always really encourage them to seek counsel, and those conversations go much easier when they have counsel engaged, right? Yes. I do think the board took a great approach a couple of months ago we had a question about the scope of practice with a nurse, and we did an FAQ document, right. And we worked with counsel from that licensee to come to that resolution. And I think it worked really well. I imagine that we'll find ourselves more in that situation of an FAQ document going forward in some circumstances where we know that we're going to really create a situation of divisiveness. I absolutely imagine that we will find ourselves in this situation again with rulemaking. Just as a reminder, the bill that became the law was actually vetoed by the executive branch in 2018. So there was clear concern even when the law became effective at the time that this process would sort of create what I would say maybe a chilling effect on regulation. That being said, we're respectful of the legislature saying we want to hear what the stakeholder feedback is, and we want to see where this falls. It's going to be a dance to try to find our way through which situations we think we might need to take down this path and which situations may lend themselves to FAQs.
Stephanie, yes. I think that it behooves us to have a robust FAQ process in these areas. But we should end up doing what we did in the Attorney General's office all the time. We'd get calls, and Kyle, and you can confirm this, you'll get calls that say, is it legal to do X? And our response is that we can't legally advise you. We'll refer you to, if in this instance, we would refer you to the FAQs. And after that, if that doesn't sufficiently answer your questions, then you'll have to go to counsel. What it means is that you're going to have a lot more gray areas where people don't go to counsel and they just make up their mind and they do what they want. And ultimately, as you know, in this instance, it'll become a battle that ultimately, I suspect, ends up in the General Assembly anyway.
Agreed. Yes. And Kim already spends a lot of time having those conversations, Kim and Nate, both with outside parties to say you really have to seek counsel on that question. But we try our best to give good guidance, but sometimes we can't put ourselves out there that way.
Well, let me ask a practical question. Even with an FAQ, that doesn't guarantee you're not going to be out of the weeds either.
Correct.
Your I mean, there's no notice and comment. There's no opportunity. I mean, you can have the greatest FAQ, and as soon as you get an objection, you're back in the box with the rule. So I mean, that's great. So as long as everybody's happy with it. As soon as they're not, we're done. I just see this slowing up the process of. It's just going to be a mess. But okay, so be it. It's a legislature. They rule.
But you may not be able to answer these questions for years, depending on how long it takes to go through interested parties, JCAR, the whole bit. I mean, it's quite a process.
I would put a shout out right now to somewhat unrelated, but I think very related actually, to the work that Jill Reardon's doing with our stakeholders. I really feel like this is an area that was a big hole for us before, and Jill spends hours every day talking, and Chelsea as well, with the associations, with constituents, with interested parties, and does so much negotiating with where we are on different issues. So, and is in really good contact with Kim and Nate as they're drafting and working on rules. So I do think that, Bob, to your point, and Dr. Saffron, I'm right. I think that there are going to be situations that are unavoidable. What I'd like to think, though, too, is that with what we're doing with our stakeholders, we do have a really good finger on the pulse of where they are on different issues that they may be in complete disagreement about, so that we'll know before we waste time pursuing an avenue that we know is going to end up being something that we should be seeking formal output or formal input on, right? So understanding, Jill might be talking to an association where she flags for us and says, you guys, this is going to go south really fast. In fact, she tells us that about every day. This is going to be an issue. I'm like, I can't hear from you anymore today, Jill. And so then we have to course correct. I think it's just going to make us probably expedite our internal process a little bit faster toward the rule, and kind of avoid that policy scenario altogether.
Ms. Luca, do you need an official motion then for the rulemaking process?
That would be helpful for JCAR purposes, because if we have that motion and then we go back to them, we've already been called back for the June meeting, and to hear their vote. I would imagine that they'll take us off the agenda if they know we're going to start the rulemaking process. So it would be helpful to have that vote.
Thank you. Do we have a motion?
Move.
Objection. Mr. Castellani seconded. All in favor, say aye.
Aye.
Aye. Opposed? Then the motion passes to move forward with the rulemaking process. Thank you.
Thank you.
Ms. Reardon, would you now give the Dietetics Advisory Council report?
Sure, thank you. Dr. Bechtel, members of the board, the Dietetics Advisory Council met on May 10th virtually, because we're doing all of our meetings. The minutes from the previous meeting from March 8th were adopted as drafted. An update was given regarding pending legislation and an update on rules pertinent to dietitians that are in process. I reminded the members of the council that there is a public hearing on some of those rules on May 17th, and offered if they contact me to get them the link so they can attend as well. An update was given regarding a short presentation from council member David Ryerson, and he did a 10-minute presentation on food insecurity and the impact in underserved areas and where dietitians can be helpful with that. The council was advised there are 620 licensed dietitians who potentially need to renew their licenses by 7/1, and that was also sent to their association and put in their monthly newsletter. There are 3 members whose seats need to be filled, and I will be bringing that to this board, to the president and to this board at the June meeting. The next meeting of the Dietetics Advisory Council is scheduled for August the 9th. And our next advisory council in general will be the Respiratory Care Advisory Council, June 8th, the day before our June meeting. Are there any questions? Thank you.
Thank you, Ms. Reardon. Ms. Montgomery, will you give the Compliance Committee report?
Yes, after approving the minutes in March and April, we moved on to rules review. We had a pretty robust discussion about clarification regarding outpatient versus inpatient evaluation rules, using of terms like psychiatric evaluation versus mental health, or the use of biopsychosocial language with regard to assessments. We had Brandy giving us a complete statistics review. And we had conversation about where are we on the application questions, and we made a recommendation on the rules to the board to adopt the proposed rules. And so at this point, that recommendation has come to the board, and Dr. Bechtel, I think at this point, and Kim, you can tell me otherwise, we are to vote on it. Is that correct?
Yes. So if we could have a motion to approve the 3 rules related to evaluation and treatment for initial circulation to interested parties.
Do I have a motion? Dr. Rothermel, second? Dr. Caparella? It's been moved and seconded. All in favor, say aye.
Aye.
Aye. Aye. Opposed? Motion carries.
We had a pretty, and I will close by saying we had a very, I think, a good, robust discussion about probation and what we, how many probationers we have, how many licensees we have, the kind of staffing and the kind of probation oversight that we would have going forward as we move from sort of a checklist probation to a more substantive, focused probation. We had conversations with regard to a very strong relationship we have with OPHP with regard to what our roles will be and what we can share and what kind of work can be done by that. We talked about the need for perhaps more staff and looking at the medical board treatment providers to ensure that they know and we know that they're doing what we expect of them. We had to address questions about issues about one bite and what's not, what's a slip versus a relapse. We had discussions that we are currently in conversation. The medical board staff is in conversation with OPHP about what is a relapse versus a slip. We had during discussions about what happens. Is there a preliminary way to get out of a neuromatic referral folks who seem to be clearly not impaired, instead of making them go through an expensive and timely, time-consuming evaluation, which comes up that says that they have no impairment. And the whole issues about, as I said before, we're looking over the application questions, and should, I think we're hoping that by the next board meeting have some proposal for the changes in the application questions, and understand that we are also combining that with a conversation about what we might be able to remove as confidential and not subject to public scrutiny at the same time. So it's sort of a belt and suspender approach. And then we had a conversation about, a very brief conversation about our quality review or oversight, both as the intervention and while the process is going on versus as well as the audit process. And the staff is still working on that, and hope that in the next several months we'll be able to come to you with there's a lot on the plate, and we have a lot of staff working at multiple levels. But the good news is I think we're tightening up our compliance and focusing. Hopefully, we'll be able to focus more on where the trouble areas, potential trouble areas and trouble areas are currently. Thank you, Mr. Chairman.
Thank you, Ms. Montgomery. Dr. Schottenstein, will you provide the financial report?
Sure. Thank you so much. So looking at our fiscal update for March 2021, we basically had a break-even month. Revenue was $834,737. That's actually a pretty fair increase from the February numbers and likely reflects the yearly April 1st due date for many of our licensees. The number of our licensees who have the deadline extension to July 1st, but typically have an April 1st deadline, appeared to be renewing in greater numbers. And Stephanie spoke to that. We expect an influx of licensee renewals at the end of June to meet the July 1st deadline extension. The cash balance stayed in the same $5.2 million ballpark at $5,215,703. And as a preview, we have revenue of over $1 million for April. And we likely have significant revenue to look forward to for our June numbers, again, based on eligible licensees waiting to renew until the July 1st deadline extension. And also, as to Stephanie's previous comments, we are sending out monthly communication to our licensees, strongly advising them not to wait until the last minute to renew, because there is a risk of running into system issues if all licensees from all of the boards who are eligible for the deadline extension take advantage of it and then overwhelm the system. So as the time approaches, we're going to send those communications out with increased frequency. On April 27th, Stephanie spoke before the Senate Health Committee regarding our budget. I think that went well. Thank you. Our spending is unremarkable. We have a 2.8% year-to-date increase in expenditure. That essentially reflects payroll. We received $6,500 in disciplinary fines and $207.19 from collections in March. Any questions regarding Finance Committee matters? There's no new business. That concludes my report. Thank you.
Thank you, Dr. Schottenstein. Dr. Safran, will you address the licensure committee?
Thank you, Dr. Bechtel. Today, for board consideration, we have 2 licensure requests. Information on each of the requests have been prepared by licensure staff and distributed to board members. Does any board member wish to consider any of those applications separately? Hearing none, do I hear a motion to approve the licensure staff recommendations for the requests of Jenna Parsach and Michael Riley, MT? Dr. Johnson moved, Dr. Coccarella seconded. Is there any discussion on the motion? Hearing none, Dr. Rothermel?
Yes.
Myself, Dr. Safran, yes. Mr. Giacalone?
Yes.
Dr. Soin?
Yes.
Thank you. Dr. Schottenstein?
Yes.
Thank you. Dr. Reddy?
Yes.
Thank you. Dr. Johnson?
Yes.
Thank you. Dr. Coccarella?
Yes.
Thank you. Ms. Montgomery?
Yes.
Thank you. Dr. Feibel?
Yes.
Thank you. Dr. Bechtel?
Yes.
This concludes the report of the licensure committee. Thank you.
Thank you, Dr. Safran. Next on the agenda, please turn to the compliance section. Do I hear a motion to approve the compliance staff's reports of conferences for April 12th and May 4th, 2021? Do I have a motion?
So moved.
Dr. Johnson, second, Dr. Coccarella. All in favor, say aye.
Aye.
Opposed? Motion carries.
Abstain.
This time, abstain. Thank you.
Abstain.
Abstain. Dr. Rothermel and Dr. Safran have abstained. Thank you. At this time, we'll consider the probationary request in today's agenda that have been prepared by the Standards Review and Compliance staff and distributed to board members. Before asking for a motion, does any board member wish to consider a probationary request separately? Do I hear a motion to approve the secretary and supervising members' recommendations for the probationary requests? Do I have a motion?
So moved.
Dr. Johnson, second. Dr. Schottenstein. We'll have a roll call. Dr. Rothermel.
Abstain.
Dr. Saffron.
Abstain.
Mr. Gacaloni.
Yes.
Okay. Dr. Soin.
Yes.
Thank you. Dr. Schottenstein.
Yes.
Yes, thank you. Dr. Reddy.
Yes.
Thank you. Dr. Johnson.
Yes.
Thank you. Dr. Coccarella.
Yes.
Thank you. Ms. Montgomery.
Yes.
Thank you. Dr. Feibel.
Yes.
Yes, thank you. And myself, Dr. Bechtel, will abstain. So this concludes the May 12th, 2021 meeting of the State Medical Board of Ohio. Do I hear a motion to adjourn?
So moved.
So moved. Dr. Coccarella, and second?
Second.
Dr. Schottenstein.
Yeah.
So the time is 2:15 and the meeting is adjourned. We have a marijuana committee meeting.
Could we have a quick voice vote on the motion to amend, pardon me, the motion to adjourn, please?
Okay. All in favor?
Aye.
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 Opposed?
Thank you. I apologize for the interruption. Thank you.
We didn't want to say goodbye to Mark, and we're hoping that we'll see him next month.
And then we have the medical marijuana meeting next. Ms. Luca, do you want to give them a 5-minute break or go right into it?
This conference is no longer being recorded.
By 2:30 for the medical marijuana. So 2:30. 15.
Okay, thank you very much.
Okay, thank you.
Thank you. Great to see everybody. Have a good month, everyone.